Good afternoon. Welcome to Community CPA's Tuesday webinar. So as many of you already know, so we regularly give webinars about various news related to businesses. And so today we're going to talk about recent immigration executive orders that were issued by President Trump, in fact, last Friday. All right, so the title of the webinar today, so we're going to talk about Trump's new immigration executive orders. And so my name is Steve Howe. I'm a PhD and a math professor. So currently I'm working at Community CPA. All right. Okay, quick introduction about Community CPA, our firm. So we, put it in short, so we have a bunch of people, energetic and skilled and professional, so we're working to serve clients. And no responsibility disclaimer, quickly. So again, by just attending and listening to this webinar, that does not form a customer relationship with us. So if you need to do anything and just by listening and do something on your own, so that does not create any relationship, does not create any liability on us. And you are fully on your own. So if you're not sure about whatever you need to do, and then if you learn something that from our webinars that you think that's relevant and you want to do something, so I strongly advise you to seek help from professionals, so including our firm, for example. All right, so let's come back to the topic of the day. So we're going to talk about two immigration executive orders or proclamations by President Trump that was made last Friday on the 19th, in fact, in the evening. So I was actually on an airplane at the time, so then I have a client texting me already. So, hey, what happened, this order, what's the impact on us? Okay, but anyway, so there are two of those executive orders. The first one, there's probably a more urgent impact. I got urgent and immediate impact. So the second one, so we'll talk about as well. So the first one is the $100,000 fee on H-1B, and the other one is the establishment of a new permanent resident stream, so the Trump's gold card, and for a price tag of $1 million. All right, so let's talk about, the main focus will actually of the webinar today will be on the $100,000 fee for H-1Bs. And so this is actually for H-1B employer, because this is just another fee that's need to be paid by the employer, but not the beneficiaries, just like other H-1B fees. So first, let me quote the exact words from the executive order. So that's one of the reasons why people get panic. So by looking at the words. Okay, so there are three parts in the proclamation. So actually there are multiple parts in the first part here. That's the main, that's the core of the proclamation. So there are three three parts, subparts, let's say, A, B, and C. So for example, in A, it says entry of an H-1B alien is restricted unless there is payment. There was a payment of $100,000. Okay, so that's the first one. So then right away you would worry if you are an H-1B worker. So did your employer pay the $100,000? And if you didn't, what happened to you? Okay, so that's the immediate worry you would have. And then the second one is probably the more scary one. It says the DHS or USCIS, Department of Homeland Security, so which oversees USCIS. Okay, in this context, they're the same thing. You can think of them being the same thing. Okay, so the DHS shall restrict decisions on petitions, on H-1 petitions, okay, who are for beneficiaries who are outside the U.S. Okay, so, and this is really scary. So if you are H-1B worker and you happen to be outside the U.S., you would see this and say, "Oh, my entry may be restricted." Okay, so that's the impression when you first read the second part. This part B here. Okay, so Part C give you some exceptions. So basically, the USCIS has the power, or DHS or USCIS have the power and discretion to make exceptions to the rule, basically pretty much on a case-by-case basis. And then the exceptions will be based on national interest. So whatever the exception has to be made in the national interest, and also such exceptions cannot pose a threat to the U.S. Security and welfare. Okay, so these are the exact words, and then by reading those, and you can also see. So let's just imagine if you are a H-1B worker, and then so how, you would be, panic over these. And so, fortunately, the White House as well as USCIS subsequently clarified the things in details. And also, if you were listening to the news, right after the President's proclamation, our country's Secretary of Commerce made some very confusing comments. Okay, so basically, Lutnick was saying that the fee is annual, not just one time. So annual, meaning that if you have a 3-year H-1B, so the employer will need to pay $300,000, not instead of just $100,000. And so basically, he made some couple other comments, which all turned out to be not what's intended by the proclamation. So the White House and USCIS subsequently had clarified some things, and so that made the situation, that eased the situation a little bit. Okay, so that basically brought peace of mind to a lot of H-1B workers now. And you can find the USCIS clarification at the web link I just provided. So basically says that the $100,000 fee, this new fee, applies only to new H-1B petitions filed on or after September 21st, because September 21st of 2025, that's the date the H-1B fee proclamation became effective. Okay, and so any new H-1B petitions filed on or after September 21st will be subject to this $100,000. And for those who are not clear about some of the terminologies I want to quickly mention. So for H-1B, so there's a H-1 petition step, and there's also a H-1 visa step. So these are actually, they're related, but they're two different things. So H-1B petition is the petition that employer files on behalf of the H-1B worker, but it's a petition by the employer for the immigration to allow the petitioner to, which is the employer, allow the petitioner or the employer to hire a foreign worker on H-1B, okay, on a temporary basis. H-1B is a temporary work authorization. As the H-1 visa is actually a visa issued to the employee, okay, to the H-1B worker. So, but there has to be a employer's H-1B petition first, and that petition, after that petition is approved, then H-1B worker can, if it's already in the U.S., we typically will change to the H-1B status right away. But if the person is outside, then the H-1B worker would need to go to consulate to apply for H-1B visa to enter the U.S. As an H-1 on the H-1B status. All right. So what this clarification says, the first clarification says, is that the $100,000 applies only to new H-1B petitions. And so, if not to existing petitions or not to petitions that were already approved, and it's all of those situations, okay? Also, it's a one-time fee, not an annual fee. So in other words, you only pay $100,000 once, and then so it does not apply to any renewals. So if H-1B typically is issued in a 3-year increment. So if you have a 3-year H-1B near the end of the 3 years, so you want to renew you can renew for another 3 years. So if you renew for the same job with the same employer, then there's no you don't pay another $100,000. You only pay it once. Okay, and also it does not apply to H-1B visas already issued. Okay, so if you had previously approved H-1B petition, you already have obtained an H-1B visa, so then this doesn't apply to you. So you can come in and out freely with your H-1B visa, just like like in the past. Okay, there's no change basically. Also, in that link, USS link, there is a basically a document. Okay, so that's each one in the link is just kind of like a summary, and then in the link you can actually click on the actual document. So this document, it's a memorandum by USS Director Edlow, so it clarifies a lot of questions people may have, people in H-1B may have. So the clarification, and also quote, this proclamation only applies prospectively to petitions that have not yet been filed. So, so if you have a existing petition that's either in process or already approved, so then you're not affected. Okay, so this only affects future petitions. And the proclamation does not apply to aliens who are the beneficiaries of petitions that were filed prior to the effective date, which is September 21st, 2025, okay? Yeah. So if you had a petition that's already filed in process or it's already been approved, so then this doesn't affect you. Okay, and or if you already have a H-1B visa not expired, so then you are still just like before. There's no change really. This proclamation does not affect you, and so in fact it even specifically says in the memorandum. So the proclamation does not impact the ability of any current visa holder to travel to or from the United States. All right, so then for people who are already in H1, really there's no change, so you don't have to worry about it, okay? And even if your H1B is about close to be expiring and you want to renew it, so again, there's no worry because the $100,000 fee does not apply to you if you already have you're currently in H1, and also does not apply to your H1B renewals. So that should bring peace to most of those people in H1B, at least for now. Okay? All right, so let's look at an example. If you have a newly approved H1B petition, so and then you're having to go home for a long time, you want to go home as a worker, so when you want to go home for a quick visit, and then you come back in H1B, so you're safe to do so. Okay, you can just go out because your petition was already approved, and you can just go out, apply for an H-1B visa at the U.S. consulate in your home country, and so there should be no issue, according to the clarifications by USCIS, okay, as well as the White House, right? And so one area that's not specifically answered or addressed by either the proclamation itself or the clarification by USS or by White House, for that matter. So is what happens if you change job from one employer to another, okay? So the people in H1, you're free to change employer. So you basically, but your new employer will have to file a new H1 petition. And that's because each H-1B petition being filed by the employer, that's employer specific. And so the fee, the $100,000 fee, is a fee that's paid by the employer, just like other fees that, other H-1B filing fees that the employer need to pay. Okay. And so all of these are employer specific. So by those consideration, I would think that if you change job, change to a new employer, when the new employer files a petition for you, that a new petition most likely, and in fact maybe almost surely, will be subject to this $100,000 fee. So if you change job, that's what may happen. So then, what are the impact of this on businesses, especially small businesses that have H-1 workers? And so so first of all, for your current H-1 workers, if you are a small business owner and you have some H-1 workers on your workforce currently, and as I previously clarified already, so then they should not be affected. So because the $100,000 fee applies only to new H-1B petitions. So then what if you want to hire a new H-1 worker? So first of all, there's people who have tried to hire H-1B workers. You should know that. So there's a quota issue. So you have to basically win a lottery, win a quota to have the H-1 quota, so then you can start the process of petitioning for a H-1 worker. And so if any new H-1 petitions in the future, so because if effective already passed, which means the $100,000 fee executive order is already in effect. Okay, so if you file a H-1B today or later, so any day, so then it's subject to the $100,000 fee. So you have to pay this fee as an employer, okay, and on top of the wage that you are paying or you promise to pay the worker. So these are additional costs for $100,000. Also bear in mind that the H-1B worker, they are free to change job. Okay, so in fact, this used to be happening a lot in the IT industries. We have seen people moving from Amazon to Facebook or vice versa, or from Google to Apple, and people move around a lot in the IT industry. And so if you're an employer, you would and you should worry that if you pay the $100,000 fee the first day, and then you get the H-1B approval, and the next day, and the H-1B worker changed to a new job. Okay, so leaves you. So then you basically, the wage part is okay because the person left. You don't have to pay him wage, right? But this fee is non-refundable. So you lose $100,000 fee by doing this H-1B petition if the worker leaves. And go to another job opportunity. So this is a very high risk for a small business, $100,000, even if you're willing to pay that fee to retain this H-1 worker, but then if the H-1, this is a free country, so people are free to leave any employment. So if they leave, go to another job, so then you loses the $100,000 fee that you paid right away. Right, so basically this fee, with that consideration, I would say that effectively shut small businesses out of the H-1B program. So because what businesses can afford to just throw away $100,000, what small business can do that? Okay, so and in fact, I would say even for large companies, for example, Google would need to worry about this too. So if they hired an H-1B employee and pay the $100,000 fee, but then if next month maybe Facebook made a bigger offer to the same employee, and then this person jumped ship, so then Google loses $100,000. So Google $100,000 for a company like Google is probably no big deal, but still that's a substantial amount of money. And also, especially if they have, for example, 100 H-1B workers doing the same thing, so then so the company can lose a big amount of money over this risk. Okay, so I want to make a couple of side comments. So the reason or the justification for the H-1B, this $100,000 fee proclamation, is that there is a abuse of the H-1B system. So it also is undercutting, or basically it's being used by many employers as a way to undercut the wages. Okay, so they're thinking that they're paying the H-1B workers lower wages than if they would hire like an American worker. These actually are not true. So from what I have seen personally, I don't see any evidence of any truth to that. So let's just quickly, so H-1B, what is H-1B? So it's so the requirements are, so it has to be, the job has to be in a specialty occupation, which by definition requires at least a bachelor's degree in a specific field of study, such as electrical engineering, as an example, right? So there are some very specific study field, and this person must have at least a bachelor's degree. And many H-1 workers have a master's or even higher degrees, but at least a bachelor's degree. So they're already trained, educated. And also the employer must pay a prevailing wage determined by the DOL. Okay, the prevailing wage is not an employer to say, oh, I think this would be our market rate. So okay, it's actually by Department of Labor. And Department of Labor goes by statistics and also by area. Okay, there's so-called statistical areas. So then so if a person's for the same job, whether the person works in Des Moines, Iowa, or works in New York City, so the pay rate is the prevailing wage is different. Okay, so that prevailing wage is set by Department of Labor, not by any individual employer. So this H-1B worker must be paid at least the prevailing wage. You can pay higher if you want, but at the minimum is prevailing wage, not just a minimum wage. Okay, the prevailing wage is what the employer is paying to the H-1B workers. And very often, from what I can see, so is the prevailing wage is at least, if not higher than the market rate. Okay, so we have employer, we have business clients. They're telling us they could hire if they hire H-1B worker, sometimes they have to pay higher than what they would pay an American worker. The only reason they're doing that is because they couldn't find qualified American workers with the kind of degree requirement or the skills that they're looking for. So this H-1B worked as a good supplement to the workforce. Okay, so and then any abuse, it may be. So but I just personally see that it's very hard to do. Okay, so and because of two requirements, right? So one is bachelor's degree or higher, and so in very rarely someone would make up a degree, right? So when they tried, and also the immigration, when they process the petition, they're going to look at the degree certificate and all that. So if there's any doubt about the authenticity of the degree certificate, so then they would issue a request for evidence and try to ascertain the degree certificate is real, is authentic. And also the H-1B worker must be paid at least the prevailing wage. Okay, so prevailing wage, just by the word, the meaning of the word, we would imagine that should be a market rate, right? So that should be a market rate, so they are paid at least a market rate, so not a lower wage. So based on those, I really don't see any evidence of the abuse, and I don't see how. Okay, but anyway, so these are my personal comments, so I don't want to go too far, too far anymore. All right, so this other second proclamation by President Trump on Friday is so-called Gold Card program. So this is formally established now. So he has been talking about this from day one in office, and in the very beginning, he put a price tag of $5 million. But now the Trump card is on sale. Okay, so with a 80% reduction in price tag, so from $5 million to $1 million now. And okay, so if you are an alien, you have some money and you want to get a U.S. residency, so you can pay $1 million as a gift to the U.S. government or specific Department of Commerce, and so then you basically have the right and you are eligible for this Trump Gold Card. And if you don't have the money, but you have a business that's willing to sponsor you, so if the business pays $2 million as a gift to the U.S. government on your behalf, okay, so then you're also in for this Gold Card. Also, according to the announcement, so this Gold Card will be processed, expeditiously. So, basically, it's a fast track immigration process. And the details are still in the making, so the rules are in the making. So you cannot apply for this yet, even if you have the money or ready to apply, you cannot do that yet. So you have to wait for the announcement. So I just want to quickly mention that. So that Gold Card program is coming. Also, I guess in part to justify his original $5 million price tag. President Trump did also announce in the same order so-called a platinum card. Okay, so for a platinum card, the price tag is $5 million. And so from what I can tell, the only difference is that for a $5 million platinum card, and you can live here in the United States for 2/3 of the year. Okay, so those rich people, they don't always live in one place, so you can live in the United States for up to 270 days without needing to pay taxes. Okay, so you still are considered a non-taxable resident if you pay the $5 million gift to the United States and get a platinum residence card in the U.S. All right, so that's the update I'm going to talk about related to the two president proclamations. And so let me end the webinar today by quickly, introducing our firm again. So we have 6 partners with emphasis in different areas. So you're welcome to, schedule a consultation with any of us. Some of our other employees as well. I didn't list everybody. If you happen to know some of our employees, and then you want to schedule an appointment with them, then you're welcome to do so. And if you have some general questions, feel free to send an email to us. Our general email box at Catherine@communitycpa.com, or call us our main number 515-288-3188. So we are open 8:30 to 5:30 every day for 6 days a week, Monday through Friday. So that's Central Standard Time. Also, you can visit us on our website, so both about our firm as well as some other webinar announcements and things of that sort. And lastly, so if you have not subscribed to our YouTube channel, we would thank you in advance for becoming a subscriber to our channel. So you can click on the subscribe button and become our channel subscriber. So then you can listen to more of our YouTube webinars. All right, so that should be it for today. Thank you for listening and attending, and that's it.